my name is Johnson. I have 2 first names and 2 surnames, so it's confusing. But I'm using this one. And you can maybe like now thinking that it's not Johnson, it's Kenson. No, it's Johnson because it's Turkish, and in Turkish we pronounce C as J. So pronunciation is like really similar to the baby powder, Johnson and Johnson. Is there anyone taking IP and the market course here? Okay. So then they already we already know each other. But for the rest of the class, because we haven't met before, am I not? Okay. So yeah, this is the name issue. Baby powder, easy. You will never forget. So I'm lecturing competition law. My background is IP, so I did my master's in IP in Queen Mary, and then back in Turkey I worked in IP area, mostly in patent issues and TNT and trademarks in Turkey for 5 years. Since 2017, I'm a PhD student at the University of Glasgow, and my PhD topic is related to it's at the intersection of patents, competition law, and it's in the technology sector, basically. So I'm qualified in Turkey, and I'm on track of being qualified in England and Wales. Hopefully, May I will be taking the 2nd stage and also qualified as a solicitor next year. So my probably the lectures that we will have together will focus on practical aspects of the issue. So I will try to give you some examples from real life and how these things that we are talking are practiced in real life. Okay. Other than that, you can always reach me. I saw Magali posted office hours today. Yes, I have an office hour, but I'm really responsive with my emails, and when I'm in my room, you can always knock and enter. The only problem is I'm living a little far from here, not living in Glasgow, so I'm not in the office every day. So your chances of finding me in the office will be higher on Tuesday, Wednesdays, and Fridays. Okay, but mostly Wednesdays. So Wednesdays generally I'm in my room. And as I said, I'm really responsive with my emails. If you write me, doesn't matter time, I will try to get back to you within the same day or maybe next week. It's the I think one of the defaults of our profession. So when you're a lawyer, you want to respond really fast. You can approach me for anything. It doesn't need to be the seminars that I'm teaching. It can be in general about your research, maybe for your dissertation topic in terms of research, conducting research, and also, I don't know, as long as it's related to competition law, it can be practicing law, you can always approach me, okay? Any questions about me? Any objections to me saying that you're not qualified, you cannot teach this course? So today's course is actually more theoretical. I generally don't like this kind of subjects, but sometimes you have to teach. So we will talk about jurisdiction and institutional structures of competition law and antitrust law. And yes, before starting, I just want to be clear. Are we all clear about the term competition law and antitrust law? When we say competition law and when we say antitrust law. Why I have this slide in here. By the way, I forgot attendance list. I will quickly grab it in the break and so get your signatures. Anyway, I'm going back to my question. Why I have this slide in here, competition antitrust law?
Because competition law is for European Union, while antitrust law is for America.
Great. I know it looks like a really simple, silly question, but I remember my time as a student And sometimes you can like think that you are getting things, but sometimes you are just like missing really fundamental stuff, and all of a sudden you are just like confused. Why we were like saying competition and now antitrust law? So competition law is the term that we are using in EU, and antitrust law is a term that we are using for US. Okay. Outline, we will look at EU and US. And if you check the schedule of this course, is like probably you saw that I am teaching the EU part of this course and Magali is teaching US. There are some courses like this. For example, I'm covering both EU and US, but in general, I'm on the EU side. Okay. So in terms of EU, first we will talk about subjects of competition law, EU institutions, sources of EU law, EU institutions concerned with competition law, brief background about Regulation 1/2003, also known as Modernization Regulation, cooperation between European Commission and national competition authorities, and we will conclude our remarks with role of national courts. And in the US, I try to make them like mirror each other. We will do the same things like subjects of antitrust law, principal statutes comprising antitrust law, and US institutions concerned with antitrust law. Any question about outline? Great. So, subjects of competition law. What is the subject of competition law? Now we are in the EU area, okay? Forget about US, we are talking about EU. What is the subject of competition law in EU? Who studied competition law before? No one. Is this the first time that you are studying competition law? Or you are just like not saying it, not to expose any questions? I will find you. If you studied competition law, I will find you. Okay, great. So actually it's on the slide. Just read it and try to tell me something. Just like think about as a lawyer. So you have a client has a question, you have a cheating paper there, you saw something, and you try to cover up like, okay, this is something, and so just read it and try to give me an answer. If you find the key term there, that will be easy. Yes?
The main purpose of the competition law is to restrain the abuse of the anti-competitive actions by the companies or you say their trade associations, agricultural corporates. So it's not restrained only on companies but also depends on other entities like government entities which naturally are not the companies but sometimes they also are engaged in anti-competitive actions.
Okay, it's perfect answer. Yes, it is right. So we call them undertakings. So we have this special term for the subjects of competition law, and we call them undertakings. We are not calling them companies because, as you said, it's broader than concept of companies, and it comprises any entity engaged in economic activity. So legal form is irrelevant. That can be a company in a traditional sense. It can be a corporation or natural person, so like one person engaging in economic activity. Also, governmental bodies or quasi-governmental bodies, if they engage in economic activity, we accept them as undertakings and they are subject to competition law. Okay, so you have to be careful if you are undertaking. Only time that is, if actually there is a task that can be only performed by public bodies or on behalf of public bodies, then we said that this is not engaging in an economic activity, so so they cannot be considered undertakings. An example is, for example, navigation safety. So if there is a, let's say, entity dealing with the scheduling this airplanes and taking off and things, it looks like, it can look like they are doing something like economic activity, but it's because it's considered that that can be only done by a public body or on behalf of public body. It's not, they are not engaging in economic activity, so they are not undertaking, they cannot be subject to competition law, okay? But the keyword is engaging in economic activity. If there is an economic activity, you immediately need to think about undertaking and application of competition law. Are we clear on this aspect? Great. So, sources of EU law. Who took EU law courses? Only one. Okay. Higher. Yeah, probably like anyone coming from Europe, they took EU law. But this slide is more for the ones coming from non-EU countries, like my country, Turkey. I studied EU law, but I always think that sometimes it's confusing, like what this like EU law, they have national laws, how these things like operating. So this slide is for you guys, for like a special treatment from me to you. So under EU law, and this is just to give you the idea, we have primary source of EU law and then secondary sources of EU law and then supplementary sources, but let's just focus on primary and secondary sources for a second. So under primary sources, we have founding treaties. So what are the founding treaties, EU students? What are the founding treaties of the EU? And they're always changing their names to make it more complicated.
Maastricht.
Okay, I heard Maastricht Treaty, and what we call them. Who said Maastricht? No? Who? Oh, I heard.
Yeah.
Oh, okay, you're not from EU. I was like looking at, okay. Maastricht Treaty, yes. And we call it Treaty on European Union. And what's the other one? And the one actually we will deal most of the time. It's on the slide.
The Treaty on the Functioning of the European Union.
Yes, it's really long name. The old name is Treaty of Rome. Okay? So then, actually these treaties are the constitution of EU, and they are determining the competencies of EU and also member states. Because if you think about it, there are sovereign member states under the umbrella of EU. They transfer part of their sovereignty to EU, so they are giving that power to EU in terms of making laws, okay? And these treaties regulating that. And obviously, they should be ratified by member states, like without ratifying these treaties, because they are treaties, regional treaty, they don't have any power in terms of member states, okay? Then there are amendments to these treaties, so they can be amended. Protocols of the treaties, they are annexed to the treaties, and they constitute integral part of that part of the treaties. International agreements that EU signed, okay, and treaties of accession. What's that? The fifth one. Treaties of accession. And obviously, it's treaty between EU and who?
I'm trying. State that wants to enter the European Union.
Yes. For example, my country couldn't get it for a really, really long time. So when there's a membership, you have to have this treaty, okay? So the state and EU signing this treaty to accept that member to the EU. If we move to secondary sources, we have regulations, directives, decisions, and opinions and recommendations. What is the difference between regulation and directive? Okay, you.
That a regulation has a direct effect in the national legal system, but the directive needs to pass from the parliament so that we have a law, a national law, which actually implements the directive. Sometimes directives also give power to the national legislator to fix some terms regarding on the basis of the national system. For example, in the GDPR, it was regulated about ages and stuff, so that it would be more close to the national legal system.
Okay,
Authorizations to.
Okay, I think it was right. So we are talking about for directives, member states should do something to implement that rules into their domestic system. Okay, whereas in regulation, we call them directly applicable. We are not saying they have direct effect, because direct effect is about the issue whether persons can rely on that piece of legislation or not. So let me put it this way. Regulation, if you have regulation, member states don't need to do anything, because it's directly applicable. When it's in force, it's just applied on member state levels, okay? And the example is, for example, GDPR, General Data Protection Regulation. And I think it's a good example, because before that, we had Data Protection Directive, okay? So they changed it from directive to regulation. And actually, this is my second question. Why they made such a change? What is the motivation, or how they decide whether they want to have a directive or regulation?
While we implement the directives to the national legislation, there is always a chance of the legislator, the national legislator, to interpret the directive in another way, other than what the Parliament of the European Union actually intended to do. While the regulation, the national legislators does not have any chance to change the text or the meaning of the act itself. So I think the EU Parliament really needed or wanted to sustain the GDPR unchanged in all EU countries.
Yes. So they had Data Protection Directive, and if you look at the preamble of the GDPR, which is like awfully long, but at one point you can see that we want to now prefer regulation, because we want to application of these rules, like consistency among all the member states, that we couldn't achieve at the time of directive. Okay? In terms of directly applicable, and direct effect. So as I said, actually directives has also direct effect. What you understand from that, like when I say they are not directly applicable, so for treaties and regulations, and in case of treaties, when they are ratified, they are directly applicable at member state level. But for directives, no. Member states should do something, their parliaments need to enact something to implement that law into their domestic system. But I'm saying that they are still, they still have direct effect. So what does that mean?
That the member states are still bound to legislate, to make laws, to implement the directive, and if they do not do this, a citizen who is harmed from the lack of legislation on the basis of the directive can ask for compensation.
Yes, and if, for example, and we call that vertical effect if there is a directive that states should implement, but if they fail to implement, individuals still rely on that directive before the national courts. He or she or it can say that, okay, there is that directive, state didn't implement it, but because it has direct effect, I'm relying on that directive, so as a national court you should apply that directive. Okay? Are we clear so far? Any confusion or anything? Great. Decisions of the Council and EC, they are binding on the persons that subject to that decision. For example, in case of EC, if there is a competition investigation and a decision as a result of that investigation, the decision is binding on the parties of that decision, and opinions and recommendations, they are not binding, but they can be influential. Okay, but for us, actually, first three is more important. And then we have supplementary sources, international law and general principles of law. And in terms of general principles of law is something Court of Justice of European Union, like interpreting the law, and also in general, like the general principles that we all apply in different jurisdictions. Okay? Any questions about EU sources of EU law? No?
What's the international agreements? Can you provide an example?
Free trade agreements, for example. So, for example, EU has free trade agreements. I think they have free trade agreements with US, and I think there's one like with Canada and things. And this is one of the issues, for example, they are discussing in Brexit. For example, when Brexit happens, UK will not be part of these free trade agreements anymore because they, like UK, will not be EU member. So they need to make this kind of arrangements with like on individual basis. So like any other, where are you coming from?
China.
China. So China has international agreements with other countries, no? It can be international or regional agreements with, yeah. Same thing for EU, and EU is signing these agreements, negotiating and signing these agreements on behalf of their members. So all members benefiting from these international agreements, like any other state.
Okay.
Okay?
And then the TU is valid, the Treaty on European Union.
Yeah, it's a regional treaty establishing like one of the founding treaties of EU. So again, if I'm not sure like whether it's like quite right, but you can think about like constitution of states. So states has their own constitution, and on the in EU we have treaties because there are like 28 currently member states, and there should be some way to common understanding how they will deal. It's a complex system, but this is like a basic overview.
Okay, thank you.
Any other question? Okay, great. So let's say what we have next slide. EU institutions concerned with competition law. So in this subject, we will talk about European Parliament, the Council of the European Union, European Commission, Court of Justice of the European Union, okay? And after finishing this subject, I have a chart actually putting all these different institutions, so you will see how they are actually seen. If you check the slides, probably you already saw it. So let's start with European Parliament. European Parliament is the institution sharing the lawmaking power with the Council of the European Union, and it doesn't deal with competition law like actively and on daily basis, but it's like more like a consultant, but it can be influential, okay? And each year it adopts competition policy report. But I can say that probably we will not see that many things that related to European Parliament in this course on the EU part. So the more important institution for us is the Council of the European Union. Let me ask you something. So in EU, one of the main bodies, so see these bodies, these institutions are not the only EU institutions. There are more main EU institutions, but I only refer to the ones dealing with competition law, okay? So the Council of European Union is an institution dealing with competition law, but then there is something called European Council as well. Again, they like to make everything confusing, so they picked really similar names for two different institutions. Let me ask you, what is the difference between the Council of the European Union and the European Council? I'm asking because I'm always confused. So if you see such a question, you can it's safe to assume that probably I'm confused and I'm putting that on the slide. And the answer is on the slide as well. No? No idea? Do you think they are same? And one of the reasons I'm asking this question is not because I will not ask like this in the exam or anything, but one of the things that I really don't like. So for example, you guys, you can make mistakes in this room. We can ask silly questions and it's okay. But you see like partners and people like thinking that they are doing really, really well in their career. They mixed up with these small things, and I think it looks so bad when they mix. If there's anyone in the room knows the difference, so just to prevent like that kind of confusions and yeah.
I think that the European difference, the main difference is that the European Council actually has the power, and it gives, it also advises the Commission, the European Commission.
Mm-hmm. So you're talking about the first one,
the European Council, yeah.
Uh-huh.
Which, on the contrary, the Council of the European Union, it's more about the implementation of the rules,
Mm-hmm.
and how these reflect to its national legal system separately.
Okay.
And that's the main difference.
I think we're quite close.
Yeah.
Yes. Anyone else? It's almost like.
First of all, it's formed by different people, like your council is formed by head of states.
Okay.
So they actually make decision of the direction of the European Union.
Perfect.
So about the Council of the European Union, actually is formed by the Minister of the Government.
Okay.
So they have different smaller council,
Okay.
which decided about different things in different aspects.
Okay. Actually, it's a 90% right answer. Okay. The only like 10% is from the Council of the European Union is actually law-making body. Okay. European Council consists of the head ministers of states. So this can be prime minister or president of member states. So the one on top. Okay. And it is dealing with general political direction of the European Union. So it's more like a political institution. Whereas Council of the European Union, states are again represented by ministers in the Council of the European Union, but not the top ministers, okay? The ones doing the hard work actually. And they are making laws with they are sharing this power with the European Parliament, okay? So, lawmaking body and political one, okay? And we will look at this one. This is important for us, and it is quite important for competition law. Are we clear about the difference? Yeah. And we will not confuse it again, okay? We can say the Council of Ministers for the Council of the European Union, and in the books I think it's also referred as the Council, but just know the difference. Okay, Council of the European Union. It is, as I said, it's a law-making body. It doesn't engage with competition law on daily basis, but it is actually, you can say that it's the source of most of the things in terms of competition law. For example, it conferred the power to apply and enforce competition law to European Commission. So European Commission can enforce competition law because the Council gave that power to them, okay? It also gave the Council to adopt block exemptions. Have you ever heard about block exemption? What is block exemption? Yes?
It's a big category of companies or the firms of undertakings that are not subject to the restriction to monopoly and competition law restrictions.
So you are saying that it's like a group of entities outside of the competition law.
Not outside of the competition law, but there are exemptions for the rule of the treaty on functioning of the European Union.
Okay. And what's the criteria for that exemption?
They choose it,
Who chooses it?
the European Commission.
Okay. And can you give me an example? No? Okay. Have you ever heard about individual exemption? Okay. So, have you ever heard of Article 101? Yeah. Okay. What's Article 101 about? Mm-hmm.
Such as vertical restraints and horizontal operation limits in the particular sector, like motor vehicle distribution and maritime transport.
Okay. Can we say that in general, Article 101 prohibits anti-competitive agreements, and then we have concerted practices and decisions of association. So there are three types of things mentioned in Article 101, but let's focus on the agreement part. So it prohibits, in general terms, okay, we will talk about the elements of Article 101, and we can talk about them like until night. But for the sake of this discussion, it prohibits anti-competitive agreements if they also affect trade between member states. Okay. So Article 101, paragraph 1 is about that prohibition. It explains what is the prohibition, and then paragraph 2 says that if you have this kind of agreement, it is void. Okay, you cannot enforce that agreement. And then we have, again in Article 101, paragraph 3. And paragraph 3 says that if you have an agreement which is prohibited by Article 101, so anti-competitive, but if it satisfies the criteria that I'm providing in this paragraph, Article 101, paragraph 3, you can escape from the prohibition. Okay, you are safe. You can be relieved and just act according to your agreement. Okay, and we call that paragraph individual exemption because it's exempting the agreements satisfying the certain conditions. Okay, this is individual exemption. Then we have block exemptions, which are based on individual exemptions. So the logic is same, but as you said, they are created by the regulations made by Commission, and they are saying that certain types of agreements can be exempted from Article 101 prohibition if they satisfy the conditions that I mentioned in my regulation. Example, research and development agreements. So if you have a research and development agreement, we have research and development block exemption in the EU. and it's in the form of regulation, and there are some conditions in that regulation. If your research and development agreement satisfy those conditions, you are safe. Okay? So block exemption is just creating exemption for certain types of agreements. Clear? So I'm saying regulation, and in theory it should be not the commission, like in theory the council should enact regulations, but council gave that power in terms of block exemptions to the commission, so commission can enact block exemptions. Okay? Clear? Perfect. And also just to show the relation and the importance for the competition law, for example, the council is the one adopted European merger regulation, which I'm not teaching, and I'm so happy about that. Okay? Okay, any question about the council? Everything is clear? Perfect. Move. EC. European Commission, it's the key enforcer in the EU, okay? It can investigate infringements, it can make decisions, impose fines, and they also investigate mergers. Let me see. Yeah, okay, I had this. So we have European Commission, okay, and it divided into separate directorates general, okay, and one of them is Directorate General for Competition, okay. So EC, different Directorate Generals, key for like different, and one of them is for competition one, okay. And we will talk about this Director General for Competition now. So as you can see, there is a Director General as a head of the DG Comp, and under that there are Deputy Director Generals. And if you look more closely, like for example, this one is dealing with mergers, antitrust, and state aid. So for the different aspects of competition law, there are, let's say, different departments and teams dealing with. Why do you think they have this kind of structure? Why they wanted to divide DG Comp in different, for mergers, antitrust, and state aid? Yes? Yes, so they want people to become expert in these fields, so that they will make more efficient investigations and things. Okay, great. Then, if you look at more closely under these Deputy Director Generals, there are some teams dealing with specific sectors. For example, in here, transport, financial services, information, communication and media, energy and environment. So there are teams working in special sectors as well. Why do you think they have, and obviously not all the sectors have special working groups or teams, but there are few sectors they have like a team specifically working on that. Why do you think the reason of that? What makes these sectors special? For example, information, communication, and media. Yes?
Because there are sectors that in general
Yes. So they are particularly important for the whole economy, right? And if you think about considering that fact, and if you also consider that we are talking about competition law, and this is DG Comp, why do you think they have different things? By the way, my questions are generally really simple. I think like maybe you can get confused because expecting something really tricky, but no.
So this is different sectors for the different industries.
Mm-hmm.
For better like to govern the competition law.
Okay.
Because like some sector they have a lot of expert for some particular industries, maybe they will have more experience in governing those industries competition law.
Okay, so actually more gaining expertise in
Yes.
these sectors. Yes. Okay. Okay, I'm giving the answer that I wanted because those sectors are prone to anti-competitive conducts and agreements. Okay. So, for example, energy sector or information or communication, in general, like you can say technology, and if you look at the decisions, there are more things related to these sector in these sectors. So they want to have special expertise in these sectors because when you're making assessment in terms of competition law, it's important to know the legal aspect. It's important to know the economics aspect, but it's also important to know the dynamics of that particular sector, okay? Because something in one sector could be uncompetitive while it's not in another sector just because of the dynamics of that sector, okay? Court of Justice of European Union. Do you have any questions so far? Yes.
Do all these people in those offices change after each election? Are they indefinite?
It's a good question. Actually, I have my notebook here that I studied here. Let's find out together. I hope there's an answer here. Okay. European Commission. President is elected by the Parliament with the proposal of the Council. Okay. And I only have that part. So President is elected by the Parliament with the proposal of the Council. But I don't think that it makes sense if they change the whole stuff with each election. Probably they are keeping them, but you can find out that, and not next week, next time we meet, you can give that answer. Okay? but I mean, when I think like logically, probably they are not changing it because if you want to gather expertise, why you change them all the time? And they are more like a state servants rather than like elected officials. Okay? Any other question? And also there is this chief economist in here next to the director general, and probably you already talked about the goals of competition law, and now it's more economic efficiency, and it is the reflection of that. It is established in 2003, and it is assisting all other departments in their cases in terms of economics analysis, and also assisting the Commission as a whole in terms of policy, like future policy. Okay? Court of Justice of European Union. So, Court of Justice of European Union comprises the Court of Justice on top and general courts. And here I listed the types of action it can hear. So let's go through them together. So what is judicial review? It's an article 263. So what is judicial review? What kind of action do you think that is? No idea? Yeah, I'm
Maybe
sorry.
it reviews the decisions of the general court.
Judicial review.
Yeah.
Okay. What else?
To take account of the policy of member states, whether they are in accordance with the European competitive policy.
So you think that it's against member states judicial review? Okay.
It's legality control of the enforcement of the regulation, review regulation.
Okay.
Just like the high-level court to review the decision and the proceeding of the inferior court.
Okay. Yes.
It's the process under which the executive and legislative actions are subject to review by the judiciary.
Can you talk like louder? Sorry.
It's the process under which the executive or the legislative actions are subject to review by the judiciary.
Yes. So it's the way how the court review the actions of EU institutions if these actions or decisions affect individuals' interests. Okay. What about reviewing fines and periodic penalties? And so you were right. Like for example, EC decision can be reviewed under this article in terms of judicial review. Okay, if there is a competition law decision of EC, it can be reviewed. What about second one? Reviewing fines and periodic penalties imposed by the EC. So, I mean, we said that actually EC's decision can be reviewed under this judicial review article. Okay, if there's a competition, if EC said that okay, there's an infringement here, that decision can be reviewed in Article 263. But then we have a separate thing for just reviewing fines and periodic penalties. You know, I mean, if there's an infringement, there's a possibility that they also impose penalty or like a fine. Why there is such a difference? Yes.
The case is the proportionality of the penalties imposed against the infringement itself. So the judge does not look after if the company is liable or not. It has already been said and it is not checked in this case. The only thing is the penalty, whether it is
Yeah. Completely right answer, 100%. Yes, so there the court is only looking at the amount of the fine or periodic penalty imposed by the commission. It's not looking or examining whether the substance of the decision is right or wrong, whether there was any infringement or anything. So when the review came to the court like this, the undertaking is saying that okay, I accept there's an infringement there was an infringement there, but I don't think that this penalty is okay. Can you like check? And it's possible for the court to reduce the fine imposed by the commission. Then action for failure to act. Any idea? Action for failure to act. Who is failing to act?
My national state,
Mm-hmm.
because they don't follow the regulation or something.
Okay. Any other opinion? Who is failing to act?
Maybe the European Commission.
Okay. And what we call European Commission in general, like European Commission is what is like, is there?
Authority.
Yes. What kind of authority?
Like the government who control power of country.
Okay. EU institutions institution. Okay, in general, European Commission is EU institution, no? So this article is related to, in general, EU institutions, including European Commission. If one of the institutions failed to act and by way of infringing the treaties, that can be subject to action before the court. Question? No. Damages for non-contractual liability. And this is actually quite similar, I'm sure, or almost sure that most of you took administrative law, and this is like very similar thing that in general state in their administrative law. What's that? Damages for non-contractual liability. Who is causing that damage? Come on.
The administration?
Yes, but I mean, administration is like an abstract concept, no? Who can do that on behalf of administration?
An official?
Yes, like servants of administration, if they cause a damage when they are doing their job, then this can be subject to action. So as we have in our administrative laws in general for state servants, similar thing is we have here for the EU. If there is an EU servant or institution damage you when they are doing their job, you can sue the EU actually to get damages from them. Okay? Any questions?
So Article 340 is all the subject of this article is also the EU institution.
Yes,
The
institutions.
server of
Yeah,
this institution.
yeah, but I mean the institution cannot do the action itself. Probably there are people doing it on behalf of that institution, but because the act is on behalf of the institution, they can be subject to the action. Okay. General court decisions can be appealed before the Court of Justice on points of law. What does that mean? Appealing on points of law.
So the party appealing would be alleging that the GC complied law incorrectly.
Yeah. So in terms of application of the law, it can be like you can argue as an appeal ground that GC didn't have the competence to review the case, or they infringe procedural rules when they are reviewing your case. Yeah, so they can only look at from the legal point of view. Actually, I skipped one part. It makes sense if we go like the other way around. So you have European Commission. European Commission can make decisions regarding competition law matters, no? You are clear in that. When Commission makes a decision, that decision is subject to appeal before the General Court, okay? And General Court can review that decision on the merits of the case. So we said on the points of law and on the merits of the case. So what is on the merits of case? What kind of review is that?
Based on the facts.
Hmm?
Based on the facts.
Yes, facts, substance. So actually, General Court look at the case as like it is the first instance court or institution reviewing the case. So they are looking at the facts, evidence, and try to see whether European Commission made a proper decision considering the merits, substance of the case. Whereas when a General Court decision goes to Court of Justice, then Court of Justice only look at it from the point of law. so whether law is applied properly. Okay? And you will see most of the time commission decisions followed with general court decision, and now it's safe to say that general court established quite a bit of expertise in competition law, so they can act like a specialist competition law court. They really know about the area, and they really know about the precedents. So yeah, like generally they make really good decisions. In terms of Court of Justice, the main, like the common types of cases or decisions, matters coming to the Court of Justice, appeals from general court, state aid cases, so commission can file action against a state who is not complying with commission state aid decision before the Court of Justice, not that important, and then preliminary rulings. So what is preliminary ruling?
Request made by a national court for the right interpretation of the EU law.
Yes, perfect. So because there is this EU law, and EU law can be applied by national courts as well, sometimes they need some guidance, and they can ask Court of Justice and say that, okay, I want to apply this rule, but I'm not sure whether how I should interpret it. And we call them preliminary ruling references to the Court of Justice. So Court of Justice is only looking at the specific questions that the national court asked to them, okay? Not the whole case or anything. It's not appeal at all. It's just like the legal questions that they're asking. And if you look at any preliminary ruling decision, there is always like a background of the case, but not in general, there should be a clear-cut questions, because otherwise they won't answer Court of Justice. They are really picky. So they have these questions, and then all the analysis is going around these questions and to find the answer to this question. Okay? Any questions so far? Everything clear? Great. Let's take 10 minutes break because I need to run to the school. Not surely. And okay, I close this. Great. Let's talk about Regulation 1/2003. Do you know anything about this regulation? And if you know, please tell me. What's this regulation? What makes it so special that it finds a place in all my slides?
Because it gave national competition authorities the power to enforce Articles 101 and 103, so just having to use national regime.
Yes. So actually, this regulation decentralized the enforcement of competition law in the EU. Okay. Before this regulation, EC was the only authority enforcing, I can't say only because still the courts were involved, but in general, only Commission was enforcing the competition law. But with this regulation, they decentralized the enforcement and gave competence to the national competition authorities and national courts to enforce Article 101 and 102. Why do you think they did such a thing? Really simple answer. I'm not looking for, yeah.
They freed up the workload on the European courts, and they just give the authorities to local courts to handle the issues, and not every case goes to European Union's courts.
Yes. So Commission said that there are so many things coming to me. I'm my workload is a lot. I need to delegate that. Okay, I cannot deal with all these things by myself anymore. So why do you think that happened? Why all of a sudden? I mean, they established this decentralized system first, saying that okay, Commission, you will enforce the competition law. But then what changed, and they decided that this is not the most efficient and effective way of enforcing competition in the EU.
So many Eastern countries are going to join.
Yes, so enlargement of the European Union. So when they first set up the system, there were less members, which means less competition matters coming to the Commission. But with the enlargement of the EU, with the new members joining the Union, that there were more cases, and they said that this is not the best way to deal with this. So I think it came into force in 2004, even though it's enacted in 2003, and since 2004, 85% of the competition matters in the EU dealt by national competition authorities. So it's a lot, like 85%. So only 15% of the matters dealt by Commission. That doesn't mean that Commission is not important anymore. Maybe on the contrary, the difference is now Commission is looking at the matters that matter more, so more important things. And you can think about it more like a supervisory institution, trying to ensure that there's a consistency between different authorities enforcing the competition law, but still Commission is really, really important for in terms of the enforcement of the competition law. If you look at the few things that regulation bring, I made these bullet points here. So first thing is abolish the notification requirement to benefit from Article 101, paragraph 3, which is called individual exemption, and now we know about what is individual exemption. No? Yes? Yes? Do we know about? Okay. So before this regulation, if you want to benefit from individual exemption, you need to apply to the Commission and to get a clearance from the Commission. So you submit your agreement, clauses of your agreement, and say to the Commission that, see, I have this agreement. It is probably infringing Article 101, but see, actually it is also fulfilling meeting the criteria listed in paragraph 3. So give me clearance to go ahead with my agreement. Okay? They abolished the system. Now there is no notification. You don't need to get a clearance from the Commission. But they didn't abolish the individual exemption. We still have individual exemption, but now we have self-assessment. So what is self-assessment? What do you understand when I say self-assessment?
That maybe, I don't know, maybe the national agencies of competition law submit their annual report on competition matters, so that the member state can actually be self-assessed and fix everything that goes wrong.
Okay. Not like that, but I like. See, when I was a student, I really like to like this kind of questions and manipulate on the answer. I mean, if you don't know, you can just like think what you think, and it just depends on creativity. So, yeah, that could be something maybe, but this is more about. It means that more work for you guys. I mean, I think most of you will go and practice law, you know, like you will be lawyers or solicitors, whatever it's called in your jurisdiction. So this means that if you have an agreement, I don't need to submit anything to Commission. As a lawyer, I need to look at the agreement and say that, okay, this can infringe Article 101, but I think it also satisfies the conditions of paragraph 3, so we are safe, so we can go ahead and act according to the agreement. And in practice, it's applied for individual exemption, but it also for block exemptions. Lawyers draft their contracts, like agreements, considering the conditions in these exemptions. So you try to have the clauses showing that your agreement is properly fulfilling these conditions to escape from Article 101. So that doesn't mean that, so you always have the risk that you can say that, okay, I believe this is benefiting from the individual exemption, but there is a risk that you can still face with antitrust accusation of the Commission or your national competition authority. But that wasn't the, yeah, so I mean, we don't have that clearance system anymore. But I think I didn't hear anything bad about this, so I think it's working quite well. Then we have, and we already talked about this, it granted the power to enforce Article 101 and 102 to national competition authorities and national courts. So it's related to decentralization of the enforcement. And third point, we closely related to the second one, establish the European Competition Network to ensure the coordination between the national competition authorities and European Commission. Okay? Any question about this part, this slide? Okay. Let's move to the cooperation between the EC and national competition authorities. So, as you can see, there are so many institutions, agencies enforcing the same rules. So it's important to have consistency between them, okay? And that can be done by facilitating coordination among these different agencies and courts. For that purpose, Regulation 101/2003, there are certain obligations in terms of cooperation, and I mentioned three principal obligations in here. This is not exhaustive, so there are more obligations, and actually I will mention a few of them again, but these are, I think, like showing, like, to give you the idea how they are doing this in practice. So first one is notification of cases. Really straightforward. So if national competition authority starting investigation about the competition matter that it will apply Article 101 or 102, they have to, or it has to notify Commission ideally before the investigation, or if they can, as soon as possible, like after the investigation started. And they can also supply this information to other national competition authorities. Okay, so they know what's going on with the other competition authorities. Then we have case allocation and reallocation. So this is something happened after the notification. And why do you think we have this kind of obligation or provision in the regulation about the case allocation, reallocation? Well, yeah.
Because it's very often the conduct just happening in one country, so many times and it's happening across the whole European Union. So if there's like an NCA that's like in Malta, it's not going to be able to as well as like an NCA in Germany or France or UK.
Okay. So what happens if they decide that they cannot? Let's say Malta Yes. So that is the purpose of this provision. Basically, when it is notified to the Commission, the National Competition Authority, which made the notification, should consider all the circumstances of the case, like the affected markets, and whether it's in a position that can gather the evidence, and ultimately whether it can bring that infringement to end. Okay, so after considering all these factors, it should decide whether I am the best authority to deal with the case. If the answer is no, and if there is a authority in a better place to deal with the case can be reallocated to that national competition authority, or maybe European Commission. Okay, can you think about a situation or like example that the national competition authorities start to investigate a case, but then it is reallocated to the Commission? Why do you think that kind of this can happen in practice?
May affect the several member states. Actually, it's not the national phone already. It covers other countries as well.
Yeah. So, for example, if we, and like this is like a hypothetical example, but I think it's just like it makes it easy to understand how it's like reallocated. Let's say there is a conduct affecting like UK, Germany, France, Italy, Malta, and in that case, maybe rather than having independent investigation in each member state, it will be more efficient to reallocate the case to the Commission, so they can just like make one big investigation and then just like decision for the whole affected markets. Okay. So if a national competition authority is already investigating a matter, and if that matter is subject to subsequent complaint before the Commission, Commission can reject that complaint on that ground. So it can say that I am not like I'm rejecting your complaint because there's already ongoing pending investigation before the national authority, and that happened in EasyJet versus Commission case. There was a subsequent complaint to the Commission, and Commission rejected the complaint on the ground that there's an ongoing investigation. Clear? Any question? Okay. Case allocation, notification. No, this is okay. Information exchange. Again, national competition authorities can exchange information each other, and also with European Commission, and that information is including confidential information. Okay. The important point is that information exchange should be to inform authorities as to the potential infringement of Article 101 or 102. They cannot just like occasionally exchange information each other. There should be a potential infringement of Article 101 and 102. Did you look at this case, Southern Europe Banana Cartel? And do you have any idea why I referred that case in here? Is there anyone coming from Italy? Okay. It's related to Italy. And you do check. So, okay. Tip. If you see something like that, don't go and read the whole decision, okay? Just like Google it, or you can use, obviously, Lexis Library and Westlaw, and try to see like a small commentary and thing that like highlighting the importance of that decision, okay? I'm not talking about the ones that we are mentioning in the handout, like in the cases section. You need to read them. But for this kind of things, just to have the idea and when you have the question, just like give the answer. Go and have a look at it, okay? It's just like small something. So no one got curious about this decision. Why this crazy woman referred this decision to this on the slide? Okay, in the case, the importance is why I referred on this slide is European Commission made a decision about the cartel, banana cartel, and they used the evidence they obtained from Italian tax police, okay? And on appeal, cartel, this company, banana company, they argue that the evidence wasn't permissible because it was received from, like, accidentally from an Italian tax police, okay? But Court of Justice said that no, it was okay for the Commission to get that evidence from the Italian tax police, and there is no need to just like get the evidence from national competition authorities. So with that judgment, actually, court gave the green light to the information exchange, not only between Commission and national competition authorities, but any national authorities in principle, okay? And in general, some other obligations, notifications of decisions. I think it's self-explanatory. If you are informing Commission about your investigations before starting your investigation, you also need to notify Commission about the decisions you made, okay? And suspension of cases. So if there is another national competition authority investigating competition matter, then another national competition authority can suspend its own investigations on the same matter or close the file partially or in full in order to ensure that consistency, okay? If you think about, like, example, is this mine?
No.
Oh, okay. Because mine is exactly the same. Let's think about if let's assume that there is an infringement affecting the UK market and Germany, okay? And so there is an ongoing investigation by, is it called Bundeskartellamt? Yeah, Bundeskartellamt and German National Competition Authority. And in this case, and if there is also an investigation of the CMA, UK Competition Authority, CMA can say that, okay, I'm suspending my investigation until Bundeskartellamt makes its own decision. I will wait for that. I want to see what will be the outcome. Or also say that, okay, I continue with my investigation, but now I'm not looking at the German elements of this case. I'm only focusing on the UK elements or other elements of the case, okay? It does not need to do that. It can continue to its investigations as well. So this is not like a strict obligation. So there can be one infringement, two parallel investigations in different member states at the same time. Okay? Power of the EC to relieve NCA of competence. What do you think? What's that about? Relieving National Competition Authority of competence.
Taking the competence.
Sorry?
Taking the competence away.
Actually, I asked the same question in undergrad course. They also gave the same answer, like prohibiting National Competition Authority to enforce competition law.
Well, not prohibiting, but just like setting them free. Like
yes, okay. That is, I think, I'm not a native speaker, but I think like relieve is like more like,
Yeah, yeah.
So doing that. So if there is a if EC already start to investigate the matter, then national competition authorities can be relieved in respect of that matter. They don't want to. They don't need to be concerned about we have to enforce competition law because there is already ongoing EC investigation. Okay. Let me ask you a question. Why do you think we have all these obligations? Notification of cases, allocation, reallocation, information exchange, notification of decisions, suspensions of cases, this relief competence thing. What is the main purpose of all these obligations? Actually, I gave the answer when I yeah.
Maybe to ensure a harmonized competition.
Yes, I already mentioned actually when I start, but yeah. So consistency. They have to coordinate. They have to have consistency in terms of application. But why do we are concerned about consistency? What happens in practical terms if there is no consistency? Let's think about a hypothetical example. You have a client. Let's say this client is undertaking, and there is a infringement, competition infringement in the market that your client is active, and client wants to file a complaint. Okay. As a lawyer, what will be the first thing that you will think of if there is no consistency in terms of the application of competition law?
We'll go to the easiest country that has to win whatever case it is that we're doing.
Loud.
So like depending on what the complaint is, you'll just look at the rules or you just look at one of the procedures to manner.
What we call that in forum shopping. So yes, so you will go to the competition authority and file the. I mean, if there are different, assuming that you have different options in terms of making complaint in terms of affected market, you go to the one most likely make a decision in favor of your client. Now, for example, in case of it's IP example, but for patent infringement, if you are on the side of patent owner for patent infringement, and if there's a German patent, I will go to the seller court because probably I will get an injunction there because they favor patent owners. So because there is no coordination, I mean, we don't have anything like a single European patent or in terms of enforcement of patent. So if we don't have this kind of cooperation and consistency in terms of competition law, this could give rise that kind of forum shopping and trying to find the agency or authority that will make a decision in favor of you. Okay, so it's really important. Cooperation in investigations, it's about if a national competition authority or a European Commission is investigating a matter, then other national competition authorities can assist them or it in its investigation. For example, let's say EC is conducting investigation and one of the, let's say, subsidiary of the undertaking is in UK, so it can ask CMA, UK Competition Authority, to conduct inspection in the premises of this subsidiary or request information from that subsidiary. Okay? And cooperation in merger control. So, are you taking merger control?
Yes.
No? Who is taking merger control? Okay. Okay. So when EU has competence in a merger control?
When it has a community dimension?
Sorry, when it creates?
When the concentration has a community dimension.
Yeah, so you need to have a concentration, like transaction that constitutes concentration and meeting the turnover threshold. And as you can see, I'm struggling with the definition because it's not my area. So in that case, we have one-stop shop system in the EU. So EC deals with that kind of transaction, that kind of mergers. So if you have a transaction fitting into that definition, EC is the authority, they will look at the transaction. But if you have a transaction, if you have a merger that does not satisfy that definition, then member states can apply their own merger rules. And in that case, if there are more than one investigation in terms of the one merger in multiple states, they also coordinate each other. Okay? Any questions so far? Okay. I think I can skip this part a little bit fast. National courts we already kind of mentioned, but in general, national courts, they can also apply Article 101 and 102, and their role is complementing the national competition authorities. So, and we will talk about these, yes, in the enforcement seminar. So there can be private enforcement for competition, or and if in case of private enforcement, forum is court, and they can also review national competition authorities' decisions, and also they can hear damages actions. They can request information from Commission if they are enforcing Article 101 and 102, and in principle, Commission should comply with that request. And as national competition authorities, they have to also send their judgments to the European Commission, okay, inform the Commission. They are also like under obligation of this ensuring consistency. So if there is a Commission decision related to a certain matter, they cannot make a decision contrary to that European Commission decision. If there is a ongoing Commission investigation or pending appeal regarding the Commission decision, the ideal in an ideal scenario, national court should stay its proceedings until the Commission decision is final, but they can still make decision without waiting the finalization of the decision if they can foresee the outcome. So let's say there is the issue is related to matter that there are like tens of decisions and they are 100%, not 100%, but 98% sure that the outcome will be in a certain way, then they can say that we are not waiting the outcome of this European Commission investigation or the appeal, we are making our own decision. And they also have to assist European Commission in their investigations, and in scope of that, like for example, if there is a need to get a judicial authorization, let's say to conduct an inspection in the premise of one of the undertaking, they should grant that authorization to the European Commission. They cannot assess whether the Commission decision is lawful. So when there is a European Commission decision saying that, okay, I will go to the premise of this undertaking and I will conduct inspection, national court cannot assess the lawfulness of that decision, and who can assess the lawfulness of European Commission?
Court of Justice?
Yes. Who said Court of Justice? Yes. only Court of Justice can assess the lawfulness of Commission decisions. Okay, let me see. That's it for the EU. I have this nice chart for you. This is not, I have a disclaimer that this is not like a formal thing or anything. This is how I think about like how the things are working at EU level in terms of competition law, and just to give you idea, particularly the ones who are not familiar with EU system, okay? So we have legislator, we already mentioned that, European Parliament and the Council of the European Union, okay? And then in executive body, we have European Commission, so they apply EU law, including competition law. And for judicial body, we have Court of Justice of European Union, including Court of Justice and General Courts. And then if we move to state level, on state level we have legislative, national parliaments. For example, UK, we have House of Lords and House of Commons, headed by the monarch, Queen. And then we have executives in terms of competition also. Don't like take it like in general executive, because who is executive body of the state?
Prime Minister.
Who said Prime Minister? Government. So executive body is in general government, but I'm just like referring in here in terms of competition law. So we have national competition authorities enforcing the competition law, and then we have judicial body, and under that we have national courts. Okay. And I put like these are yellow because in terms of EU, these parts are the or these bodies, institutions are the one mainly enforcing competition law. And you can see the difference in here. This is US chart, okay? And we have federal level and then state level again in the US. So federal level, we have legislative Congress, they are making laws. And then again, for in terms of antitrust law, we have executives, executive bodies, Department of Justice and Federal Trade Commission. I will talk about them. And then for the judicial part, we have Supreme Court and Federal Courts. Then if you move to state level, for example, like California is a state within United States. For state level, you have legislators, state legislators, their name change state to state. For example, for California, it's called California State Legislature. And then we have executives, so the ones executing antitrust laws. And these are state attorney generals, okay? And for the judicial, we have courts at state levels as well. So they have courts at federal level and then state level. So it's quite complex system. Okay? My thesis is comparative, and I'm struggling with like how this is like how they are doing this like decisions and effects. So from this we can start looking at the US system quickly. What's the subject of US antitrust law? It's on the slide. So now we are in the US antitrust law region. You can forget about EU. Remember, we started with the subject of competition law in EU, and we said undertakings. And what is the subject of antitrust law in US?
Persons.
Yes, persons. But what's persons?
Naturals of like people like us, or just companies, entities.
So the it's not quite like on theoretical level, it's not like 100% right, but we can say that like a equivalence of undertakings in competition law as persons in antitrust law, and it's again a broad concept. It can be companies or individuals or legal entities, and it comprises like individuals or entities doing business in the United States, or foreign individuals, entities doing business abroad when that affects U.S. customers. Okay, so again, it's a broad concept. It can be individual, company, or yes. Any questions about the subject of the antitrust law? Okay, principal status comprising antitrust law. Probably you heard about this Sherman Act. Section 1, prohibiting agreements, anti-competitive agreements, similar to Article 101. And then Section 2, prohibiting unilateral abuse of monopoly power. And we will see why EU is not, like in Article 101, we have abuse of monopoly power beyond unilateral. So there can be a group of undertakings abusing their monopoly power. But anyway, so Section 2 Sherman Act is about abuse of monopoly power. Then we have Federal Trade Commission Act. And actually Section 5 is quite broad of this act. And it comprises like almost everything, including the things covered by Section 1 and Section 2 of the Sherman Act. And probably you will see there are like debates about whether it's like too broad, and because it's so flexible and it's enforced by FTC, Federal Trade Commission, it's not always like really easy to predict what they can do with that. Then we have Clayton Act, Robinson-Patman Act. I wrote this Hart-Scott-Rodino Act in gray. It's because we will not deal with that in this course. It's merger. It's related to merger control. And then they have state antitrust laws on state level. So different states that have they have their own state antitrust laws. Okay. Let me see. Okay, so in terms of federal agencies, so actually U.S. institutions concerned with antitrust law, and it's immediately like looking at Department of Justice and FTC. But what is missing in here in terms of institutions dealing with competition law? Remember the chart? So it's looking at this, but actually legislator and judicial bodies are also the institutions dealing with competition law at federal level. But my slides looking at this executive part immediately. So okay, I mean, let me see. Yes. So actually, I think kind of heading is kind of misleading, because they are not the only institutions. They are executive bodies enforcing competition law at federal level. We have Department of Justice, and similar to European Commission's directorates, it has different divisions, and one of the divisions is Antitrust Division, okay? And Department of Justice is headed by the Attorney General, and that different divisions, specialized divisions headed by Assistant Attorney Generals. For example, currently the one at the top of the antitrust one is Makan Delrahim. And I think, as far as I know, they are quite political. Like, for example, this guy was conservative, and the appointment system is also like quite political, and so it's dealing with the Civil Enforcement of Sherman Act, and it has exclusive jurisdiction in terms of enforcement of Sherman Act. So only Department of Justice can enforce Sherman Act. Then it can enforce Clayton Act and in Taylor Robinson Patman Act, but it abandoned enforcing it like a while ago. And then it has criminal enforcement powers. And this is again exclusive jurisdiction. So only Department of Justice can engage in criminal enforcement of antitrust law in the US. Then we have Federal Trade Commission, and I think it's like quite confusing why they have two institutions doing like similar things, but they have. So Federal Trade Commission is independent enforcement agency. It has 3 bureaus: competition, consumer protection, and economics. And so as we mentioned, there is this act, FTC-A Act, and for that act, in terms of that act, FTC has exclusive jurisdiction in terms of enforcing it. Clayton Act, again, it can enforce. Robinson-Patman Act, actually this act is generally used in litigation between private parties. So also FTC hasn't enforced this act for a long time, and it does not have criminal jurisdiction. So it cannot engage in criminal enforcement of antitrust law. So their jurisdictions overlap. Sometimes I don't understand like what makes like why in one issue they are looking at certain issues and why the other doesn't. But there is a cooperation between them, so they are talking to each other. For example, for my thesis, I'm looking at the decisions related to patent holdup, and generally Federal Trade Commission makes decision about these issues, not the Department of Justice. Okay. State agencies, so the ones at the state level, basically they're attorney generals. They have authority to enforce state antitrust law, and they can also federal antitrust law as private plaintiff. Okay, and they can be private plaintiff on behalf of their citizens or on behalf like just as a state at federal level. So, because most of the time anti-competitive conduct or like agreements have interstate and intrastate effects, they generally need to coordinate with other states and also with the agencies at federal level when they are enforcing antitrust laws, state antitrust laws. Let me see. I think that's it. Do you have any questions? Just 1 minute late. Thank you. And yeah.